Welcome to the Deep Dive. Today we're tackling a really high-stakes business question. If you hire someone and they mess up, how bad does that screw-up have to be before you can legally just walk away from the entire contract?
Exactly.
We're diving into a contracts classic. It's a cautionary tale about a dry cleaner, a very expensive neon sign, a little bit of rust, and one extremely ill-fated splattered tomato.
This is where we really have to analyze the line in the sand. It's the crucial threshold of performance known as the doctrine of material breach.
Right.
Our mission today is to give you the exact diagnostic tools that courts use to decide when a failure is, just annoying, maybe worth a small lawsuit, versus when it's fatal and justifies tearing up the whole agreement.
Right, because the financial risk here is massive. If you walk away too soon, thinking the other side breached, then suddenly you become the one who breached.
And you're on the hook for the entire contract value.
So let's start with that fundamental principle. What is the rule that separates a minor failure from a total game changer?
The rule is pretty clear, actually. You can only legally back out of the whole deal, what lawyers call repudiation, if the other party has committed what's called a material breach.
Okay, a material breach.
Yes. If their mistake is deemed non-material, you have to keep performing your side of the bargain. You can sue them later for the cost of fixing their minor problem, but you can't walk away.
So how do courts decide what's material? Is there a test?
There is. It's a multi-factor test from the common law, and it really focuses on a few key areas. It's essentially a balancing act.
And what are the, say, two most important factors that seem to always dominate the court's thinking in these kinds of disputes?
Absolutely. When a court is weighing everything, they're looking primarily at two things. First, did the injured party still get the substantial benefit they bargained for?
Okay, did you pretty much get what you paid for?
Exactly. And second, can the injured party be easily compensated for the problem with money? If the answer to both is yes, you got the main thing you wanted, and the annoyance has a clear price tag, then the breach is almost certainly non-material.
Let's test that framework right away with the case that costs one man over $5,000. Walker and Company v. Harrison. Let's analyze this step by step. First, what are the legally essential facts?
So Walker and Company leased this giant custom-built pylon neon sign to Harrison, who ran a dry cleaning business. The lease was for 36 months, and it was going to total over $5,000.
A lot of money back then.
A huge amount. And crucially, the contract included a specific maintenance clause. It required Walker to keep the sign clean, repainted, and repaired.
Okay.
After the sign goes up in July of '53, Harrison starts complaining almost immediately. A tomato had splattered on the clock face.
A tomato.
Yes, there was minor rust on the chrome and spiderwebs. Walker was slow to respond. Finally, in October, Harrison just sends a telegram declaring the contract terminated. He stops paying
And Walker sues.
for the entire remaining balance.
And what was the core legal issue that the court had to resolve?
The precise legal question was whether Walker's delay in cleaning the sign, the tomato, the cobwebs, the rust, was a breach so significant, so material, that it justified Harrison walking away from 3 years of payments.
What rule of law did the court apply to figure out if that maintenance failure was material? Could you state the full rule and break it down into the elements the court has to weigh?
Sure. The court applied the common law test for materiality. It requires weighing several factors to see if the breach was severe enough to basically destroy the purpose of the contract. The key elements from the restatement were:
Okay.
1, the extent to which Harrison got the substantial benefit he expected. 2, whether he could be adequately compensated in damages. 3, the partial performance already completed by Walker.
And there are more.
Yes. 4, the hardship on Walker if the contract were terminated. 5, the behavior of Walker. Was he being willful or just negligent? And 6, the degree of uncertainty about Walker's future performance.
Thank you. Now for the court's elemental analysis. Let's walk through the three most critical elements. How did the court apply that first element, the extent to which Harrison obtained the substantial benefit he could have reasonably anticipated?
Well, the court looked at the primary purpose of this multi-thousand-dollar contract. It was to have a huge illuminated pylon sign advertising his dry cleaning business 24/7.
Right, to get customers.
Exactly. And despite the debris, the infamous tomato splat and the spider webs, the sign was still up, it was still lit, and it was still advertising. The court basically said Harrison had substantially obtained the main thing he bargained for.
So that factor heavily favored Walker.
Very heavily, suggesting the breach was non-material.
That feels a little harsh. I mean, Harrison paid for a clean, maintained sign, and he got one covered in a dry cleaner's worst enemy. A nasty splat of organic material.
I agree, it feels that way, but that's where the second element comes in, the extent to which Harrison could be adequately compensated in damages.
So could you just fix it with cash?
That's the question. And the court saw the complaints, the tomato, the minor rust, as trivial defects. Harrison could have just hired a local worker to clean the sign for a few bucks.
And then just deducted it from his monthly payment? Or sued for it?
Exactly. Because the damage was so minor and so easily quantifiable, the court found damages were a perfectly adequate remedy, again pointing to a non-material breach.
Let's zoom in on the fourth element, the hardship on Walker if the contract is terminated. This is where it gets kind of jaw-dropping because the sign was custom made.
Right. This factor was probably the single biggest reason the court sided with Walker. The contract itself said the sign was, quote, especially constructed for the lessee and is of no value unless so used.
So it was worthless to anyone but Harrison.
Pretty much. Allowing Harrison to walk away over a tomato would have forced Walker to eat the cost of the remaining 35 months of payments. We're talking over $5,000 on an asset he couldn't reuse. The massive financial hardship on Walker just screamed that Harrison's move was unwarranted.
What about the fifth element? The behavior.
Yeah.
Walker was definitely negligent. He took weeks to clean a sign. Didn't that count against him?
It did, but not enough. The court said, yes, Walker was slow, but they looked at the nature of the breach relative to the nature of the contract. The breach was a delay in cleaning, a trivial duty. It wasn't an intentional refusal or something that destroyed the sign's function.
So even his negligence wasn't enough to overcome the other factors.
Correct. The court reasoned that it couldn't overcome the overwhelming evidence that Harrison still got the main advertising benefit and that terminating the contract would cause ruinous hardship to the sign company.
And after synthesizing all these factors, what was the court's final conclusion?
The court ultimately concluded that the delayed maintenance was non-material, and because Harrison's reason for terminating the contract was invalid, his later failure to pay the rent became his own material breach.
Oh, wow. So the tables turned completely.
Completely, and that's the peril. Harrison's ill-advised telegram turned him into the bad guy, justifying Walker's claim for the entire accelerated contract balance.
That is a brutal lesson. Okay, here's a visceral hypothetical to highlight the difference. In Walker, the sign was just dirty. But imagine Harrison was using it to advertise a special weekend sale, and Walker's electrical work failed right after installation. The sign is dark, unrepairable, for that critical 48-hour period.
Yeah.
Is that failure material?
Yes. Oh, absolutely. That changes everything.
Yeah.
Because that failure immediately violates the core substantial benefit rule. If the sign is dark during the specific critical time it's needed for advertising, say, for a major holiday sale, the customer gets zero value. The whole purpose of the lease is defeated.
So the difference between a dirty sign and a dark sign is everything.
It's the difference between an annoying failure and a fatal breach.
So if we step back, what's the actionable three-step checklist for you, the listener, to use when deciding if you have the right to legally terminate a contract?
This is really the disaster avoidance framework. You have to follow this process before you even think about sending a termination notice.
Okay, what's step one?
1. Isolate the event and the risk. Identify the specific failure. Then ask yourself if your desired outcome, the substantial benefit of the contract, has been severely impacted. Is the core purpose of the deal destroyed, or are you just inconvenienced?
Step 2.
2. Apply the compensability test. Ask, can I fix this problem easily by spending money and then subtract that cost from my next payment or sue for it later? If the answer is yes and the cost is small, the breach is non-material. You have to keep paying.
And the final step.
3. Weigh the hardship and the acceleration clause. Before you terminate, you have to consider the financial hardship your termination will cause the other party.
Especially with custom goods.
Exactly. If your walking away causes disproportionate financial ruin to the other side, a court will almost certainly find that your action, the repudiation, is the real material breach, turning the tables on you completely.
This analysis of Walker really teaches us that contracts are not voided by minor irritations or temporary annoyances. They're governed by the law of substantial benefit and proportional risk.
Precisely. The importance of measuring the materiality cannot be overstated. Sending that premature telegram is, as the court put it, fraught with peril.
For you, the listener, here's a final thought to consider. Harrison was crushed by that unforgiving acceleration clause, which let Walker demand the full $5,000 if he missed a single payment. Considering how subjective this materiality test is, a judge has to decide what a substantial benefit is. What value would Harrison have gained by explicitly defining the standard of performance in the contract itself? For example, stating that failure to clean the sign within 48 hours of a complaint would constitute a material breach. We encourage you to explore the power of contractual definition over a judge's interpretation.